Hello, folks! Welcome to our second unit, which is Legal and Ethical Issues. This unit covers two of our course competencies, legal being one and ethical being the other. So we're taking 2 full weeks to get through it. So this first week we'll focus more on legal, and next week we'll be talking more about the ethical issues. Now remember that every unit in this course will have learning objectives. These objectives are part of the national curriculum, which will follow as an accredited educational program. Do you remember from last week who our accrediting agencies are? If you're thinking the ARC, STSA, and CAHEP, then you're right. Yay, nice job. These objectives give you a nice idea of what to expect from the unit and a good idea of what your takeaways should be as well. So take a moment now, pause the video, read through the objectives on this slide. You'll notice that the last 2 objectives have to do with documentation, and they're italicized and underlined. And that is because you'll be covering documentation with Steve in your Intro to Search Tech course later. So I'm not going to spend much time on it here because you're going to go through it in his class as well. So let's start out by talking about HIPAA. HIPAA stands for Health Insurance Portability and Accountability Act. So this is something that took effect in 2003, and it requires you as a health professional to protect the privacy of and provide security for protected patient health information. Protected health information is any individually identifiable information about a patient. This includes things like a patient's name, address, medical record number, phone number, even unique identifiers that may appear to their appearance, or even like the town that they live in, anything. So you have to be really careful. This slide has a link to a really great article that explains protected health information and has some specifics about how HIPAA is meant to safeguard it. You'll use this article to complete your discussion board this week. You'll also see it linked on Blackboard, so don't worry if you don't click on it here. But here it is if you want it. Also, here are some examples of HIPAA and violations of HIPAA violations. So copying any portion of a patient chart is considered a HIPAA violation. This is one reason why we're really careful. We ask you guys not to take any part of a patient's chart home with you. We've had students long ago got in some HIPAA trouble, because they were unable or didn't fully remove the patient's identifiable information from the preference cards that they were taking home to use in their case prep. So we don't allow students to do that anymore as a result. Taking home patient chart materials, as I said. Discussing patient-related information in public areas. You never know whose ears are listening to you or talking about the locker room. We've had an issue in the past with students talking about cases and revealing patients' protected health information while they're speaking to their classmates down in the locker room, walking through the hallways of the hospital, even in the elevator. So you have to be really careful. And then, of course, we don't talk about any protected health information about our patients, certainly at home with your partner, with your kids, with your mom, with your friends. We certainly don't disclose any of that. It's none of their business. They have no right knowing. Okay, so again, telling family and friends about a specific info from work, disclosing information about media, to the media about maybe some trauma. This happens every now and then. There'll be like a high profile case. Somebody's the victim or the perpetrator of a violent crime that makes the news. And then pretty soon people are coming out of the woodwork and they're saying, hey, I heard that person went into surgery up, in your department. Did you work on that surgery, or do you know anything about that surgery? What did I look like? Do you think he's guilty? Another example might be like a school bus crash victim, or prisoners after a crime, the condition of a known community member, so like the weatherman. The best way to keep people from prying about this confidential health information, or even like I might say, hey Susie, I heard that my next door neighbor, like Ron John, went to surgery the other day and I don't know what he went for. Can you tell me? You work there. So the best way to keep people from like prying and asking you those types of questions is just to deny any knowledge of it at all. Oh, I didn't know. I didn't hear about that shooting, or Oh, no, I don't know anything about your neighbor at all. I'm sorry. Even if that person was your patient. So, anyways. The main purpose of HIPAA was to improve portability and continuity of health insurance coverage, um, to ensure privacy of health information, and to decrease fraud and abuse in healthcare. With these new changes, they found that privacy of protected health information would be compromised. So, with the portability, the privacy would be compromised. So, they incorporated privacy regulations on top of it. So think firewalls, anti-malware, and requiring strong passwords for security reasons. Okay. So HIPAA is taken very seriously. Violations can come with some pretty severe consequences. So civil penalties can reach up to $100 per violation and up to $25,000 per year. Criminal penalties can range between $50,000 and $250,000 depending on the nature of the violation. You can also lose your job or be removed from this program, absolutely. So it pays to be really careful. This includes social media, especially in the last few years. This is an area that has had it's been a problem area because we're this day and age we're so used to putting our lives on social media, and if you're excited about something that you did at clinical, something that you saw at clinical, it's really easy to get yourself in trouble by posting about it on your social media sites, just like you would share other things, but you have to be very careful. So it's best not to post anything about clinical or about work, just to keep yourself safe in that way. Western Technical College has removed students from their programs in the past for talking about their clinical rotations on social media. We've had problems in the past as well in this program. So many people across the country have also lost their jobs because they were indiscreet and shared protected health information on social media or elsewhere. So keep it off your Facebook, keep it off your Twitter, keep it off your Insta, whatever is cool these days. Keep it to yourself. Keep it off of there, okay? It's just not worth it. So HIPAA protects the privacy of protected health information. Remember that protected health information is any identifiable information that has to do with a person's health, healthcare, or payment for healthcare. So some more examples of protected health information would be their name, address, birth date, social security number, any photos of that patient, their medical record numbers, fax numbers, if anybody uses those anymore, their email address, even like their health plan beneficiary numbers, account numbers, certificates or license numbers, vehicle identifiers or license plate numbers, even make and model of their car. Okay. Examples of what you're not allowed to do. Now, this isn't an inclusive list, but it gives some good examples. Accessing your own child's health information personally is not allowed. You have to have one of their providers do it who would normally have access to that information. Looking for birth dates, addresses, appointments, and test results for family, friends, and neighbors. So Aunt Clarabelle calls you and says, Janie, I know I have an appointment coming up next week, and I couldn't get through to the operator or my doctor's nurse, and I just need to know what time my appointment's at. Can you look it up for me, honey? No, Aunt Clarabelle, I can't, because that is a HIPAA violation. For work purposes, you would have no reason to look that up. So, as a favor to Aunt Clarabelle, you also can't look that up, okay? Let's see. Reviewing a patient's record just out of concern or curiosity, not okay. I guess going back to looking up birth dates, addresses, etc. Say you're throwing a party and you can't remember your friend Joey's address to send him an invitation. No, you may not go into his medical record to look up his address. Okay, that's what that's all about. Looking up a staff member's medical or financial info. Maybe you're curious about why your coworker's been out for the last week. No, you can't go in and see if he's sick. Okay. Discussing any patient information with your family or your friends or your roommates or your boyfriend or your girlfriend or your kids. No, can't do it. Discussing patient information with staff when it's not related to your job. Okay, sometimes we see some really interesting things. So be careful that what you're talking about is work related. It's okay. So like say say you're talking to a coworker because you had a novel situation in your OR and you want to talk about, how the surgeon dealt with it, maybe what kind of instruments they like to use on a humeral fracture that, you've never seen a humeral fracture with this doc before. This is the kind of stuff they use. This is the situation we had with the patient. That's fine. But if it's, gossiping about this thing that you saw in the OR, that's a little bit on the dodgier side as far as HIPAA is concerned, okay? Let's see. Also, talking about patient information with other staff when you're not in a secure place. So again, that brings us back to like the locker room or walking the corridor of the hallway or the elevator if there's somebody else in there, okay, etc. Even walking around a corner and not knowing if there's someone standing on the other side. It could be that patient's family member, okay, hearing you talk about them. Reviewing a patient record to use info in a personal relationship, for example, to check out your husband's new wife and her medical conditions, okay? You can see where that might be tempting, but absolutely not involved, not allowed. Compiling a mailing list from hospital records for any reason except as defined by your job duties. So again, birthday party invitations, holiday cards, etc. Let's move on. We're going to compare law versus ethics. So I'd like to make this clear now since we'll be diving into ethics next week. Hopefully we can help there to be less confusion. So what it comes down to is actually the people that these things are applied to. So laws apply to the population as a whole versus ethics, which govern a specific group of people. So healthcare providers follow both laws and ethics when practicing their profession. Generally, laws are designed to discourage behavior that may cause harm to other individuals versus ethics, which promote behavior that helps other individuals. So law and ethics are separate things, but they can be very closely tied to each other. Some examples would be like ethics may influence the creation of laws, which makes sense, but ethics themselves are not enforceable by laws. Ethics are standards of behaviors within groups, like religious groups. Different religious groups will have different ethical principles between them. Same with organizations like PETA, or more applicable to this program and your profession, the AST membership has its own set of ethical principles. Okay. So I wanted to put out a few base legal terminology out here for you. Some legal terms that we're going to go look at in a bit closer in the following slides, which is law, liability, torts, and malpractice. So first up, let's define the term law. Laws are society standards. They're enacted and enforced by governments to protect all individuals and groups from harm. That definition comes from Fuller's Surgical Technology Principles and Practices. You don't have that book. It's up in the lab. It's either purple or it's white, depending on which edition we have up there. So you can certainly, in your lab, pull that open and take a look. Your textbook does break it down a bit further into different types of law, which we'll get to in just a minute. Violations to law will result in consequences which are punitive in nature, meaning they punish. As healthcare professionals, we do have a responsibility to know and to understand the laws surrounding our role. Okay. So laws enable society to be peaceful, orderly, and cohesive. We're going to talk now about where laws come from. So constitutional laws are those that are written into the U.S. Constitution. This is the supreme law of our land. The constitutional law trumps other types of law. Statutory laws are those that are developed on the state level and signed by the state governor. They're prescribed by the action of a legislature. Okay? This is why some things will be illegal in certain states but not in others. An example would be the State Nursing and Medical Practice Acts. The right to die legislation, legalization and or decriminalization of marijuana, some things where you might see something that applies to one state but not necessarily another. And in recent events, we've got the Safer at Home order here in Wisconsin that was applicable to Wisconsin but not necessarily any surrounding states. They would have had their own or none at all. And also mask mandates are state to state as well. Or county by county, etc. Administrative law refers to the regulation of government agencies like OSHA or the FDA. So OSHA is the Occupational Safety and Health Administration, and they ensure safe working conditions. The FDA is the Food and Drug Administration, and they regulate food, drugs, and cosmetics in this country. Judicial law is also known as common law, and its principles are based on precedents, that is, principles that have been created by previous court decisions, which act as examples for judges in the future. Okay? So judges will look back at similar cases and similar situations and see what types of judgments were put on those situations. Each state has laws for licensed professions within the state. So if those laws are broken, the state licensing board may take action against the individual in addition to whatever crime or civil consequence they might face. So you might be thinking, but surgical techs aren't a licensed profession, and that's true. So let's talk about that. So how are legal boundaries defined for the surgical technologist? Licensed professionals like doctors and nurses will find themselves in trouble if they violate their state practice acts. For unlicensed professionals like surgical techs, the boundaries are set by civil and criminal law. For example, it's illegal to act as a nurse without a license. So, if a surgical tech practices as a nurse, they will be breaking the law. Even if a nursing task is delegated to a surgical tech, the surgical tech is appropriately supervised and the tech is liable, even so, for any negligence or criminal wrongdoing. So, what's the difference between a criminal offense and a civil one? Criminal offenses are considered to be acts against society. Punishments may include fines, jail time, or both. Some examples of criminal offenses would be robbery, murder, embezzlement, discrimination, etc. Civil law refers to wrongdoings between one person and another, as opposed to against society as a whole. So there may not have been any criminal laws broken, but the rights of one person were infringed upon by another person. Punishments are fines and are called damages. So one example would be violating a person's privacy by accessing their medical record without official reason to do so. Sounds familiar, right? From our talk about HIPAA just a few minutes ago. So in addition to laws, the surgical technologists and other health professionals will find themselves guided by hospital policies and procedures. Accredited hospitals and other healthcare facilities must provide all employees printed details of the policies and procedures required by that facility. The facilities will update policies and procedures periodically as the laws and practices change. The employees are made aware as these updates are made, and they're not necessarily given a printed copy again, but it's certainly made accessible to them. In the future, when you are in this role as a professional surgical technologist, it will be your professional duty as a surgical tech and as an employee to stay current on these changes. So, what kinds of information will you find in your hospital policies and procedures? The policies will describe administrative and logistic operations, so how things should be done. This may include an organizational chart, which is a graph that looks almost like a family tree, demonstrates the structure and hierarchy of the hospital and how everything fits together. Other documents may include a chain of command and a description of the employee identification system, identification badges, for example, and when they're to be worn, etc. The privileges include things like vacation days, benefits, leave, wellness programs, things that you would be paying attention to when you get hired, just to see what kind of package you're walking into. Information on salaries may include a low, median, and high salary range for a particular position, and also how starting salary is determined. This is very common walking into a hospital. They tend to have these things sorted out. Whether it's based on schooling or experience, there's usually a system to that. So the operating room procedure manual will describe safe practices for the OR in that specific institution. Types of procedures may include infection control, aseptic technique, disinfection and sterilization of surgical instruments, room turnover between procedures, equipment data, and chemical information. So we're going to move on now, and we're going to get into some more legal terminology, I should say, that you really need to know. So delegation is the transfer of responsibility for an activity from one person to another, and that's on page 10 of your Surgical Technology Principles and Practices, which is, of course, your main textbook. There are limitations, however, to what may be delegated to a surgical tech, so make sure you know the practice acts in your state. Also, understand what is in your policies and procedures for the institution or the facility that you're employed. Typically, you cannot administer medications. You can prepare and deliver them to the surgeon for administration, but you may not be the person who actually places that medication inside of the patient. So you are not the one pushing the plunger on the syringe. Understand? You cannot typically count without RN supervision. You cannot do patient assessments. You cannot perform invasive procedures. You cannot witness a surgical consent. You cannot independently circulate in Wisconsin. So later in this term, you will be going to clinical in the circulating role, and what that means is in our setting, what that means is you are going to go to the hospital, you're going to be in the OR, but you will not scrub. You will be assisting the circulator with their circulating duties. You'll be plugging cords in, tying gowns up, observing the surgical tech, watching the procedure, becoming familiar with the OR, because it takes a little bit of time. It takes a little bit of time to get used to that OR because it's a foreign place to most people, okay? So there are also conditions of delegation that must be met. So the person must be legally permitted to perform the task. They have to receive the proper training, and they have to be competent to perform the task. Another level of that is, besides these things, they have to feel confident that they're able to perform the task. So if they've taken all the tests and gotten all the training, but they still don't feel like they can do it well, if they still don't feel confident in the task, then they shouldn't be doing it. So accountability in surgical technology refers to accepting responsibility for a task that you completed. A person who delegates a task retains accountability for it. Okay, so if a nurse delegates a task to me, they retain accountability for it. However, all healthcare workers are expected to know their state practice acts and so are also accountable for a task that was delegated to them. The short story on this is, just because a task was delegated to you by the surgeon or a nurse doesn't mean that he or she retains all the accountability for your actions. So don't accept a delegated task unless you're confident that it's within your skill set and you're willing to hold accountability for it as well. Liability is an obligation to do or not to do something. Corporate liability refers to the corporate body itself. In criminal law, a corporation is liable for the actions or omissions of its employees. Personal liability refers specifically to the individual and to their actions. A tort is a civil wrong that may be intentional or unintentional. Remember that civil means against another person or their property. Torts can be, again, intentional or unintentional. So let's go a bit further on that in the next few slides. Let's see. We'll start with intentional torts. These are willful acts against another person. Some HIPAA violations will fit into this category as a violation of privacy. Defamation is a statement that damages a person's reputation. Slander is a verbal defamation, and libel is written defamation. I remember this slander being verbal because slander is when they say something about you. So you've got the ass and slander and the ass and say. So slander is when they say something about you, and libel is written defamation. Civil assault is a verbal threat or action that makes another person fearful that they'll be harmed. Civil battery often goes along with civil assault, and civil battery is actually touching another person without proper consent, whether harm is done or not. False imprisonment is illegal detention of a person without consent. Every year, I seem to have a few students who are confused about just what a tort is. What does that word mean, tort? And the quickest, easiest way I can think of to describe it to you is, think of it this way. Crime is to criminal law as a tort is to civil law, because torts are against an individual, okay? So yeah, maybe that would help a little bit. So each of these, invasion of privacy, defamation, civil assault, these are civil, these are torts that go along into civil law, okay? Unintentional torts are the most common form of liability. So negligence is an unintentional tort. It's an omission or commission of an act that a reasonable and prudent individual would not do under the same circumstances. Some examples would be retained objects in the body, objects left in the body cavity, burns, falls, improper positioning, which could lead to a patient injury, mistaken patient identity or operative site, improper specimen handling, and poor handling of medications. So no one is going to do these things on purpose. These are unintentional, they're accidental, but a reasonable person acting within your role should be trusted and accounted on not to allow these things to happen. Okay. Abandonment is an example of an unintentional tort that could be as simple as stepping away from the patient before properly applying safety belts onto that patient. So like say you bring the patient in and you transfer them over to the bed and you're like, oh, I forgot a warm blanket. So you step away to get a warm blanket, leaving them unsecured to the OR bed. That is without placing the safety belt across their lap first. Failure to communicate between healthcare professionals could result in injury to the patient. And finally, loss or damage to a patient's property could be considered an unintentional tort. So think they have to take their dentures out for surgery. They have to take their glasses out for surgery. Oftentimes, if they bring jewelry to their appointment for surgery, they have to remove that jewelry. The kids bringing security animals, or comfort items. If we lose or damage those items, that could be considered an unintentional tort. Malpractice is a professional misconduct that results in harm to another person. Essentially, this is negligence that's committed by a professional. So remember, negligence is the omission or commission of an act that a reasonable and prudent person would not do under the same circumstances. So 4 elements must be proven in order for negligence to be present. Okay? For negligence to be present, these 4 elements must be present. Number 1, a duty to the patient exists. So a duty to the patient is initiated the moment the patient receives treatment or care from a hospital or physician. Okay, a duty to the patient exists. The second one is that duty was breached when a failure to meet the standard of care occurred. So in some way, the duty was breached. The third is that breach of duty resulted in damage to the patient. There has to be damage done for negligence to occur. Okay, and the fourth and final one is the breach of duty has to cause injury to the patient. So if there's a breach of duty and the patient was harmed, but the breach didn't cause that harm, then it's not negligence. Okay? So those 4 things have to be present for negligence to be proven. If all 4 elements are not present, the courts may enact, here it is, the courts may enact the legal doctrine res ipsa loquitur, which is the thing speaks for itself. We'll talk about the legal doctrines in a couple minutes, but bookmark this in your brain. This one means the thing speaks for itself, which in this case means the harm obviously came from the action in question, even if we can't prove it. And then they may use that legal doctrine in order to push the case along. Anyways, so in speaking about malpractice, the following terms come into play. Deposition is testimony under oath, with only a court reporter instead of a judge. Okay, that's a deposition. The plaintiff is the person bringing the suit. The defendant is the person who's been accused of the crime. A subpoena is the court order that requires someone to appear for a deposition. Remember, which is giving testimony under oath to a court reporter. The jury is a group of one's peers who decide the outcome of the case. Perjury is when a person intentionally lies under that oath. And the trial is when both parties present evidence to achieve a resolution or to determine a person's guilt or innocence. So moving on from malpractice terms, let's turn our attention to the legal doctrines that I mentioned before. These legal doctrines were developed to help ensure accountability and responsibility. Okay, so first we have the doctrine of personal liability. This says that the health professional is liable for his or her own actions, even if an authority figure like a physician says that they'll assume responsibility. Okay. The doctrine of respondeat superior is also called let the master answer. This says that the employer is responsible for the actions of his or her employees. Okay? This sounds like corporate liability to me. But when we're speaking of legal doctrines, it's respondeat superior, or let the master answer. The doctrine of the borrowed servant says that the one who's controlling the employee has greater liability than the one paying him. Okay, so think about that. Are the administrators of the hospital controlling the minutia of what you're doing in that OR, or do you think the surgeon or the nurse have more control over that? Okay, so the closer the supervisor is to the person who made the mistake, the more liability that person has. Okay, so the doctrine of the borrowed servant says that the one who's controlling the employee has greater liability than the one paying him. So think about this. The surgeon does not have complete control over the acts of the perioperative patient team at all times. Okay? Some examples would be instrument and sponge counts and mixing medications. The surgeon is liable only when he or she has the right to control and supervise the way in which the task is performed. So who's the one who sets up the policies and procedures for these counting procedures and med mixing, etc.? The facility. Remember, they're the ones who put out that set of policies for the logistics of your job. Okay? The doctrine of res ipsa loquitur is also known as the thing speaks for itself. This is used to prove negligence when all four elements of negligence are not present. We just talked about this on the last slide. And last but not least, the doctrine of foreseeability. As health professionals, the surgical team needs to be able to identify possible risks to the patient. This doctrine makes it possible to be held liable for failing to anticipate a risk to the patient. Think about it. If you didn't check over your equipment before the day started, or you saw that there was or you noticed that something was defective, or that there was gross contamination on the table left over from the room turnover that didn't get cleaned for some reason, and you ignore it, or you don't recognize it as a potential problem, then you could be held liable for any damage that occurs to that patient as a result. Let's see. So we'll run off this week's lecture by touching on these traditional principles of healthcare staff. Traditional principles. Ager primo translates to the patient first, and this might seem familiar, especially from last week, because this is the motto of the AST. Primum non nocere translates to above all, do no harm. And this is one you also may have heard of before. It's part of the Hippocratic Oath that's taken by our physicians. So that's all we've got for this week. Next week, we'll dive further into legal ethical by getting a little bit comfier with our ethical side of things, okay? So I hope you guys are having a great week. I hope you guys are enjoying your surgical tech education so far. I hope you have a fantastic week and a fantastic weekend, and I'll see you soon.